The Honorable, the Deputy Speaker.
As we continue the debate after tea, I recognize the member for Caroni East. You have 25 minutes of your initial speaking time. Kindly proceed.
I will suffer them. Yeah, so they are forced to listen. Those who have ears to hear, let them hear.
Oh, yeah.
Mr. Deputy Speaker, I was at the stage where I made this statement that there have been a number of Joint Select Committee meetings, and for some unforeseen circumstance or reasons, these ceased, and postponement after postponement. And I have really a legislation timeline of this whistle protection bill, but I wouldn't go into it into detail except to say that, as the Attorney General said, that there were about 9 or 10 meetings, and there are about 5 reports, 5 interim reports. And then on the 19th of September 1916, the JSC was the last time they met and was never reconstituted in the subsequent sessions. Thus, no final report was laid from the Joint Select Committee. And that is important to note. Why do you set up a Joint Select Committee when you abandon it altogether for about 3 years and then want to come to lay in Parliament and a bill, and then stating that is not the bill, is a new bill? So we are confused as to really what is the bill. On the 23rd of September 2016, the second session of the 11th Parliament began, no bill. 21st of September 2017, second session of the 11th Parliament began, no bill. Third session of the 11th Parliament began 29th September, no bill. 9th of April 2018, the Attorney General brought the Whistleblowing Protection Bill, number 8 of 2018, and brought forward from the third session. And on the 12th of April 2018, it was published in the Gazette, volume 57, number 46. And on the 17th of September 2018, that's last year, Standing Order 79-3 invoked motion to carry the Whistleblower Bill 2018 into the fourth session and moved by the Leader of Government Business. The 27th of September 2018, the third session of the 11th Parliament ended. And on the 28th of September, the fourth session began. And today, being the 1st of May, probably about 7 or 8 months into this session, we're now beginning to debate this whistleblowing legislation. And Mr. Speaker, Mr. Deputy Speaker, it's sad when you tell the country that you came out to ensure that you delivered on your promises from your manifesto, and what you told the people that you're going to do, you will in fact do. So this administration told the country that they are going to bring about this legislation. They started it in December 2015, and it took them 4 years, almost 4 years later, to bring back this piece of legislation. And then they want us to support this piece of legislation without major considerations from the deliberations of the Joint Select Committee in camera, Mr. Deputy Speaker. As far as I read, I have the copies of the 5 interim reports of the Joint Select Committees. And may I refer to them? In the first interim report of the JSC, there were requests for submissions from stakeholders. Around 16 stakeholders. The chairman informed members that invitations for written submissions were requested from 16 stakeholders. And they named the stakeholders, contacted the Law Association, Criminal Bar Association, DPP, Trinidad and Tobago Transparency Institute, Chamber of Industry and Commerce, PSA, Public Service Commission, Police Service Commission, Teaching Service Commission, National Union of Government, and so on, Anti-Corruption Investigation Bureau, Witness Protection. So the entities were given a deadline of January 8, 2016 to make their submissions. We are not in any position to determine today whether those submissions were made and considered in the preparation of this bill. Have they been taken into account in terms of the deliberations and the bringing together of this bill by the Attorney General? Then the committee also agreed that invitations for written submission will also be requested from 24 more stakeholders. So you have 16 stakeholders here, plus 24 more. That's 40 stakeholders. We are not in a position to determine how many stakeholders made presentations or submissions, and we don't know whether any of those submissions and presentations were incorporated into the legislation. So how can you ask the opposition to consider supporting a piece of legislation where there were 40 submissions supposed to have been made, and we are totally ignorant whether any submissions were made and whether any deliberations took place on these submissions, Mr. Deputy Speaker? Mr. Deputy Speaker, they were important submissions that ought to have been considered. The judiciary, the Police Complaints Authority, the Environmental Management Authority, Energy Chamber, Industrial Court, ATIC, Bankers Association, TTSC, exactly what my colleague, the member for Barataria was talking about in some of these organizations, what will happen. Credit unions, Trinidad and Tobago Police Service, the Defense Force, Hewitting Law School, UWI, University of Trinidad and Tobago, COSTAT, OAS, European Union, World Bank, CFATIF. You would hear one of these recommendations or any discussion on any of these things by the presentation of the Attorney General. Here it is. We have a minuscule piece of bill without any really being brought together properly. And this is one of our problems that we have as an opposition team, that every time a bill is brought, it has so much difficulties and so much things that need to be amended and corrected, as one of the last one that was corrected 100 times. Yes. About 100 times. So we don't know whether this incorporated any of those recommendations or submissions. So 40, in addition, Mr. Deputy Speaker, the chairman had advised members that in an effort to update the media on the committee's plans and to officially launch the call for submissions from the public on the Whistleblower Protection Bill, the 15 media conference was scheduled. The conference was held. How many submissions from the public came? What did the public have to say? What did these 40 organizations have to say on the bill, Mr. Speaker? Nothing. We are in the dark, and you're asking us to support that? Suppose they made some strong recommendations that went against the flow of this bill. How are we to know what really occurred? And you had the opportunity to continue the Joint Select Committee, come up with your deliberations, accept the submissions or refuse the submissions, get the recommendations made, incorporate it in the bill, and bring a better bill to the Parliament today, so that we could have a bill that was carefully thought out after submissions and recommendations by the 40 organizations that we ought to have sent in their recommendations. So we have some of the submissions on some of it, but have they been considered? You have ATIC, Central Bank, NATO. So this is the second interim report. We had about 7 or 8 who made submissions. And the committee made comments on some of them. But have these comments been taken into consideration and put into the bill? For instance, the Central Bank. There was a recommendation in the definition of designated authority, the word "in" is missing after listed. The definition of detrimental action should be expanded to include not only the actual sanction that the whistleblower is likely to experience, but also the threat of the sanction in that regard. Consideration should be given to replacing the word "means" and the word "includes" and so on. And the committee agreed, and there's a comment for committee's comment. There's a column. The committee agreed that means should remain, subsection so-and-so, wide enough to capture this concern. The concern cannot be captured in this piece of legislation. And there are comments in the comments column from the submissions of the various organizations. A few of them, Trinidad and Tobago Transparency Institute, the committee already noted and agreed to make the changes. The committee agreed to cross-reference this concern with the Equal Opportunities Act. Was that done? The committee agreed to cross-reference this concern with the Equal Opportunities Act. The committee agreed that the breadth of the definition of employee in the bill will cover board members, and so on. So the point I'm making, Mr. Deputy Speaker, here are critically important suggestions, recommendations made by major stakeholders in Trinidad, a few of them, about probably 15 out of the 40, and we don't know what has happened and where have they gone. So it is unacceptable for us to have to debate a bill where work was supposed to be done on the bill. The committee was supposed to have concluded its work with the relevant recommendations and submissions, and that remained not concluded. So where are we? We're debating something in vacuum. 40 organizations supposed to submit. Some submitted, some they were waiting for submissions. The whole thing defunct. And your comment will bring legislation. What is really the motive now? We have to ask, what is the motive of bringing this whistleblower protection today?
Prematurely.
And is it in conjunction with what happened today as well? Was this planned? Was there something planned today, Mr. Speaker? Mr. Deputy Speaker, I have been in this politics 25 years. 25 years. And since 2001, I've been a member of the House in the Senate. And from 2003, 2004, I was a senator in 2007 and a member of this House from 2007 to now. So many of my colleagues have been around as well, and before me. But the politics...
Mr. Deputy Speaker, Standing Order 48-6, please.
Sure. I didn't say anything yet. What are you fighting about?
Oh, thank you. Member for Carney East, right? How would you like to handle it? Retract, or would you like to reword your statement?
Mr. Speaker,
In terms of in conjunction with what happened today and so on, you know what you said?
No, I was just trying to make this statement. There's nothing offensive, and trust me.
No, but for the record, so what? You're going to retract it? What you're going to do?
What did I say that I need to retract?
You know what you said, member.
What's that?
You know what, Leader of the House, you know what you said.
I can't remember what is it? If you tell me, and I'll retract. All right, I'll retract what
Member,
it is.
hold on, one sec. In conjunction with what happened today, right? It was a simple statement, but I think it had some weight with it. So could you retract, please?
No difficulty in me retracting it, Mr. Deputy Speaker. I do.
Right, proceed.
I do. That's not, but I think the message had. All right, Colonel.
Again, member, 1 second. Right? I think the precedent has already been set in terms of you retract, full stop. Please, right? Retract, full stop. Right.
Mr. Deputy Speaker, I retracted and I move on. So then we come to the third report. The third report had recommendations from the Integrity Commission, from Afra Raymond, the Trinidad and Tobago Securities and Exchange Commission, AmCham, and so on. And they made some very significant comments and contributions, but would be too long for me to bring into reading some of the comments made by the various organizations. The reports contain them, but just let's say for the Integrity Commission, the comments of the committee noted that the threshold in this section of the IPLA created a lower standard than the bill. However, the committee agreed to consider raising this fine and conviction period in section 21E of the bill. That was not done. The committee instructed the Chief Parliamentary Counsel to examine maximum fines for both summary and indictable offences in relation to 21E of the bill. That was not done. And here it is, the Integrity Commission made some recommendations because there are major organizations which deals with integrity in public life and so on. And every one of us in Parliament has to subject ourselves to filling out the forms before the 31st of May. And if they made that recommendation, where is it absorbed into this new bill? And this bill is very pathetic. It's a very pathetic bill, and we cannot support the bill in the form that it is now, because these recommendations are not included in it, Mr. Deputy Speaker. Then we have the copy of the 4th interim report and 5th interim report, about 5 or 6 pages each. They, in fact, asking for postponement and postponement. This is a government that wants to tell the people that they came prepared to do the things which they were elected to do. And after 4 years, when work was supposed to be done from 2015 to 2018, 2019, nothing was done. The committee became defunct, and now you're coming to tell us, accept this piece of bill, Mr. Speaker. How unrealistic, how wrong. And when the opposition makes the statements, we cannot support this because of X and Y, they say that we are not patriotic, we are not supportive, we are not an opposition for the people, but we remain strong so that the comments and value statements of the members of the public and the organizations must be taken into account in the consideration of any bill, Mr. Deputy Speaker. You cannot leave out the major organizations and say you're bringing a bill, and when the bill is passed, the various organizations have tremendous difficulties with the bill, and the bill is really of no use to the entire country. Mr. Speaker, Deputy Speaker, I move on to really some of the clauses, and I have to ask some questions in relation to the clauses. And it's for the Honourable Attorney General to answer some of these if he feels like answering, but we don't get any answers to some of the questions that we usually ask. Clause 2 of the bill is President by proclamation. It will provide for the coming into force of the proposed act on the date fixed by the President by proclamation. We had the Procurement Act finished. We took 5 years. The Honourable Mrs. Bissessar, when she was Prime Minister, laid the procurement legislation within the first 28 days of us coming to office in 2010. We worked diligently for 2 years on that procurement legislation in the Joint Select Committee. It was kept back by 2 members of the opposition then. We finished it in 2015. It was completed late in 2015, but 4 years later is not proclaimed. You're telling me that this will be proclaimed? When is this going to be proclaimed? The government is incompetent. They cannot do what is required of them. They cannot deal with the issues. Now, the other clause 3 would provide that the act shall have effect, though inconsistent with the Constitution. They suddenly wake up that this needs a 3/5 majority. But when we told them the last piece of legislation needed a 3/5 majority, they railroaded us. They don't want 3/5 majority in that, but they know that they can't escape without a 3/5 majority on this. And we are only here now because they need our support. If they didn't need our support, you think this debate will be continuing now, Mr. Deputy Speaker? They would have wrapped it up. And they would have said, well, I don't want to hear the opposition anymore. We go into committee stage and they finish because it needed a simple majority. But thank God this needs a 3/5 majority so that we could stay here and battle it out with them and show them that they are incompetent and they have not taken into consideration the things that are needed to be done. Clause 5 of the bill provides for the application of the proposed act to disclosures of improper conduct, irrespective of whether the conduct occurred before or after the coming into force of the proposed act. Every piece of legislation now they are bringing before or after coming into force the proposed act. So you're making legislation for now and the future, but every time you're making the legislation, you're going back. What is the reason for wanting to go back? Isn't legislation supposed to be prospective rather than retrospective? Is there a reason that this is the second piece of legislation that they're telling us that they want to have a retrospectivity in it? That is unacceptable. Make legislation from now into the future. Why you want to go back? The last bill had the same going back. And this is putting fear into the minds of decent citizens of Trinidad and Tobago. Decent citizens are fearful of this government. Fearful.
Very.
Part 2 of the bill, Mr. Deputy Speaker, Division 1 of this part, would provide for protected disclosures. All right, protected disclosures. What is really, so the whistleblower is protected. By Clause 7, the employee of an organization will be able to make a disclosure of improper conduct within the organization to a whistleblowing reporting officer. An organization, a little establishment with 10 people, have to now have a reporting officer and then a whistleblower reporting unit. So 10 people in an organization, privately run, they have to appoint a whistleblower or a whistleblowing officer, and the whistleblowing officer have to report to a whistleblowing unit within the organization. And we have, as was mentioned by the Attorney General and my colleague from Oropuchis, over 77,000 type of businesses and organizations and companies registered in Trinidad and Tobago. The Attorney General has said 105,000, but 20-something of them are not functional. So what will happen to them? Each one of these now have to have a reporting officer. And the Prime Minister spoke this morning a bit of somebody who is designated. So you designate one of the 10 people. What criteria you use to designate somebody to be the reporting officer? And how do you select your reporting, your whistleblowing report unit? Listen, you know what confusion and chaos going to exist in this country with those 77 different companies plus other organizations who have to put this into place? Total confusion. Total confusion. So you're bringing laws into Trinidad and Tobago which you know are not workable and cannot be functional, and you expect people to accept this. That is the type of ability and skill that you all have as a government, little visible skills. A designated authority listed in the schedule. Now you have, how many companies you have in the schedule here? How many organizations in the schedule? You have 21 organizations in the schedule as designated authorities. 21. All right, a designated authority listed in the schedule. A disclosure would need to be based on where an employee has reasonable grounds. So the employee has to know, what he considers reasonable grounds. Is he a lawyer? He could work it out in his mind. A fellow on the street want to make a report. He will have to consider whether it's reasonable grounds. What was reasonable ground for him is not reasonable ground for X or Y. And what is not reasonable ground for the court. So he has to determine as the whistleblower what are reasonable grounds to believe that improper conduct has occurred. So who determines this? Is it the whistleblower determine reasonable grounds? Or he makes a whistleblower statement, and where it goes from there, who determines whether that is reasonable or not? So that improper conduct has occurred, is occurring or is likely to occur in the organization. But my colleague from Baratara spoke about likely to occur. How in God's name would somebody know that something is likely to occur? What is he seeing or she is seeing? You're clairvoyant, and then you become a whistleblower for something in the future that you haven't experienced, but you believe that is going to happen. Can't be. This can't be correct. This can't be. A disclosure made by a member of Parliament would not amount to a breach of privilege. Up to now, we're trying to find out what that really means. Honorable Attorney General, you are a very brilliant man. You speak well. You are very learned. I have a tremendous amount of respect for your ability to communicate. I would really love you to tell us what this really means. A disclosure made by a member of Parliament would not amount to a breach of privilege. I could sit down, and if you want to give the answer, or if you want to wind up.
Thank you, Honourable Member. The concern, I wouldn't take the opportunity to wind up. The concern was how the law would articulate against Section 55 of the Constitution, which provides the immunity from privilege for parliamentary members. And what was requested here was consideration coming from Mr. Ramadar, that, member for St. Augustine, forgive me, that we ought to make sure that if the Parliament wanted to give a disclosure under this, a member of Parliament giving a disclosure would not breach the rule of privilege if that was done. It was taken from the English precedent of similar value.
Appreciate it. Thank you very much. You have cleared up some issues that I had mentally on this aspect of it. Clause 8 states, specify the conditions that would need to be complied with a disclosure to be regarded as a protected disclosure. Well, they listed some conditions there, but these conditions are amorphous, and they could be interpreted any way, one way or the other. So I don't have much hope in that Clause 8 issue. Clause 10,
Honourable Member,
yeah.
your initial speaking time has elapsed. You have an additional 15. Do you care to avail yourself? Right, kindly proceed.
Thank you. Clause 10, an anonymous disclosure would not be a protected disclosure. However, if the identity of the person making an anonymous disclosure becomes known. So here it is a conversion from an anonymous whistleblower to a known whistleblower. So what is really an anonymous whistleblower? And in today's age, you think a person reporting something on X, a person X reporting on somebody Y, remains anonymous. What justice is there for Y to have to respond to accusations made by an anonymous person? And when does that anonymous person become a non-anonymous person? Yeah, go ahead.
Honourable Member, the law specifically proposes that anonymous whistleblowing activity is not acted upon. So there's no circumstance. It's filed, and if the person becomes known, it can be activated. Once the person becomes known, because these things happen, at that point the person will have it flow through if deemed suitable and have the opportunity to have a defense of being a whistleblower. So no activity on anonymous witness statements, but it can be received, and if known, something happens after.
Why do we have the consideration of an anonymous whistleblower? Why do we have that encapsulated there in the first place? We shouldn't even have that consideration, because it gives the wrong thinking and the wrong meaning that anybody could go and give some information about person Y, and that person is hiding behind the scene and remaining anonymous. I think you will understand what it is I'm speaking about. Well, Chapter 11, Clause 11, speak about the internal disclosures. A required employer to establish and publish within his organization internal procedures for dealing with disclosures. Here is another burden on that organization. Beside having to get a reporting officer and a whistleblower reporting unit, they now have to have internal procedures for dealing with disclosure. Who formulates those internal procedures? On what basis are those procedures brought forward? How can it work in conjunction with the unit and the whistleblower? So that is vague and ambiguous and amorphous. Now, Clause 13, there is a question of a reasonable time. Clause 13 says, would require whistleblowing officers to notify whistleblowers of the status on their respective disclosures within reasonable time. I think this needs some straightening out, because you need to give a time frame for that. Division 3 of Part 2, for external disclosures now, which is Clause 14, you have a whistleblowing reports unit consisting of a director and such other officers as are needed. I made this statement just a while ago, Mr. Deputy Speaker, that there are 21 designated authorities. So each one of these designated authorities now has to get a director and such other officers as are needed. So you will tell me now that the Integrity Commission has to get a director and such other officers for this whistleblowing thing? Is there the EBC has to get a whistleblower and they have to get a director and a team? Who appoints them? how they come to be a significant part of this, or the Equal Opportunity Commission or Customs and Excise, how are they appointed? Who appoints them? These organizations, these institutions have a way of being elected. These organizations have a way that they are appointed or elected by the president, etc., and so on. So who appoints the directors? And who appoints these officers? That doesn't make sense at all. So you're having a director of these 21 designated authorities, and you don't know who appointing them and what would be their role. So that also needs some careful consideration. Part 3. Part 3 of the bill provide for the protection of whistleblowers. Clause 18, taking of the detrimental action against a whistleblower who has made a protective disclosure. No difficulty with that, but the whole question of protection of whistleblowers is something that is frowned upon internationally, because here's a man, A, making a report on B. He make a report, you don't know whether it's true or false, but he protected. He protected. So a man feels protected. I say, you know, I'm going to be protected by this whistleblower legislation. Let me make a report, and let me fight it out. And so a person comes from anywhere, makes a report on person B, and protected. This whole thing about whistleblower protection is against my grain. You cannot protect somebody. You should not protect somebody when they're going to incriminate somebody else to such an extent that it could cause serious damage to somebody else. So I don't like this whole thing about protection. Protection goes against my grain. You can't protect somebody because you're now putting in the legislation that if they came with some false information and so on, they could be subject to criminal or civil liabilities and so on. So you're allowing them to come in. But then you say if they come in and they do something wrong, they're subjected to liabilities and so on. The last 2 points I have on the bill itself here, I'm very happy to see that Clause 28 will enable the minister to amend the schedule subject to affirmative resolution. We have always debated whether it's negative resolution or affirmative resolution. It's important that Parliament has a look at some of the schedules if the minister wants to change the schedule. And Clause 29 speaks about the regulation subject to affirmative resolution of Parliament to carry the proposed act into effect, which is another area that we are very happy about in terms of the regulations being subject to affirmative resolution, which is the way it should be, that Parliament dictate. Mr. Speaker, in the last few minutes, I have a voluminous amount of work that we were able to look at and do some work and research in terms of a comparative analysis, one paper from the Australian Association by Professional and Applied Ethics in Adelaide, a comparative analysis of whistleblower protection. And let me read from one part. As a result, the overriding purposes of ensuring that revealing wrongdoing in organization is used to correct and strengthen ethical behavior in Australian organizations, and that the person who reveals the wrongdoing does not suffer as a consequence seem to be lost. The paper then compares the rationale of the Australian legislation with that of the UK and USA. These acts have a very different approach to each other and to the Australian legislation, particularly the United Kingdom Public Information Disclosure Act, but arguably just as ineffective. So a comparative analysis of whistleblower protection shows that these things are ineffective and the issues are really lost. And one more point on that. Consistent case study evidence indicates that whistleblowing, even when acknowledged to be meritorious, typically results in victimization of whistleblowers. This is what has been stated here earlier, and this is something that is a real issue, victimization of whistleblowers. Then there's another research on rights and protections for whistleblowers, Practical Law, United Kingdom, Articles 2, 2003. And you have different columns. employers' requirements, whistleblowing restrictions, procedures, overview, etc. And they compared France, Japan, United Kingdom, and United States. And just one example. Are there any restrictions on the subject matter of whistleblowing complaints? France said yes. Japan, no. UK, no. US, no. So there is no conformity or no unanimity across countries which have adopted the whistleblowing legislation. It must be a serious risk to the company relating to accounting, financial, auditing, bribery, or breach of banking regulations, said in France. Another question answered, is anonymous reporting permitted? France said no, Japan said yes, UK yes, United States yes. Are there any restrictions on who can receive whistleblowing complaints? France, yes, there are restrictions. It is subject to data protection regulations on the processing of personal data, including restrictions relating to cross-border transfers. Japan, no. United Kingdom, yes. US, no. Does the accused have a right to access information in the whistleblowing report? France, yes. The accused also has a right to correct or delete inaccurate data. Japan, no. United Kingdom, yes. The accused also has a right to correct or delete inaccurate data. So, Honorable Attorney General and members of this House, there is significant research done worldwide and internationally to help us guide. If you're considering the regulations in the future, these important information could be a guide to help you make the regulations. Now, the current state of whistleblower protection law in Trinidad and Tobago. This is a document called Disclosure Today, and is a review of Whistleblower Protection Bill 2015 Trinidad and Tobago by Disclosure Today. Attorney General, I think you know this document and who it was dedicated to. I wouldn't raise that now. But Disclosure Today is a United Kingdom organization with local offices in Portugal and Trinidad and Tobago. And below is a non-exhaustive list of laws and rules that the committee should take into account when considering the proposed whistleblower protection law. And Honorable Attorney General, I didn't hear you mention what are some of the other laws that should have been brought in conjunction with this for consideration in the making of this bill. Criminal law, sector-based laws, specific anti-corruption measures, human rights law, access or right to information laws, laws on classified or privileged information, media law, contract and employment law, labor law and so on, professional reporting duties, codes of conduct. So of its significance, defamation and libel laws, restricted confidentiality rules, data protection rules, and bank secrecy or other secrecy laws, such as the Official Secrets Act 1911 to 1939 UK, which still forms a part of the Trinidad and Tobago law, could pose a challenge. So some of these laws that were mentioned just a while ago could pose a challenge in the whole management of this whole whistleblower legislation. And there are other pieces of research, like extract from the Civil Society report, Spotlight on Sustainable Development 2017.
Remember, you have 2 more minutes.
Yeah. So, Mr. Deputy Speaker, the lack of whistleblowing protection framework leads to many forms of retaliation. So a framework has to be considered. We don't see any evidence of this framework being done properly. So in closing, Mr. Deputy Speaker, I want to answer the Attorney General. You should not have stopped after the JSC. You felt that there was clear evidence that there would not be conclusive work to continue. You just can't accept that one person within the committee was opposing something, and you stopped all the work of the Joint Select Committee. A lot of the things I mentioned here would have been taken into consideration. You asked for the opposition support. Are we prepared to include whistleblowing legislation? We are prepared to look at the whistleblowing legislation we're speaking, but there are so many deficiencies at the moment, and at this time it remains unacceptable to us. This country is on trial, you said, fighting for survival. We are working with you. We have worked with you on so many of the pieces of legislation. We have corrected so many pieces of your legislation. We have put so many amendments. What is our value system? Our value system we share with you. We are a responsible opposition. Our value system is a very high responsible value. We take our people first, but we must protect the constitutional and fundamental right of every citizen. I thank you, Mrs. Deputy.
Leader of the House.
Deputy Speaker. Mr. Deputy Speaker, I beg to move that this House to now adjourn to Monday, the 6th day of May at 1:30 p.m. At that time, we will continue debate on this whistleblower bill.
Honorable members, the question is that this House do now adjourn. All in favor say aye. Aye. Any against? The ayes have it. In accordance with Standing Orders 11 and 12.1, this House now stands adjourned to Monday, the 6th of May, 2018 at 1:30 p.m.